So, the United States Court of Appeals in the Fifth Circuit has made a very important decision that has a lot more far-sweeping ramifications than just the very case that it is designed to cover for the moment. Texas had made all abortions illegal during this pandemic. They banned all abortions, considering them non-essential. The Supreme Court upheld that decision when it was brought forth to them. They relied very heavily on a 1905 law, which basically was an individual did not want to get a vaccination. The federal government stepped in and said, no, we are forcing you to get a vaccination because it's a matter of, excuse me, wipe your eyes. There we go. It's a matter of public health, and therefore the public safety trumps one's personal liberties. And the decision here basically is pretty broad, and it will allow for the United States government to trump your personal liberties. Let's read a little bit of this, but basically, I'll give a caveat. It's 47 pages long, and it's very dry, very legal speaky. So I'll summarize basically. The beginning's pretty easy to understand, though. To preserve critical medical resources during the escalating COVID-19 pandemic on March 22, 2020, the governor of Texas issued Executive Order GA-09, which postpones non-essential surgeries and procedures until 11:59 p.m. on April 21, 2020. Reading GA-09 as an outright ban on pre-viability abortions on March 30th, the district court issued a temporary restraining order against GA-09 as applied to abortion procedures. At the request of Texas officials, we temporarily stayed the TRO while considering their petition for a writ of mandamus directing vacatur of the TRO. We now grant that writ. Essentially, basically, a district court put a restraining order, a temporary restraining order on the judgment to ban all abortions. The Supreme Court said, yeah, we'll let that stand while we discuss it. And then they came back and said, no, we do agree. Abortions are not essential. There is a blanket ban on all abortions. The drastic and extraordinary remedy of mandamus is warranted for several reasons. We don't need to go into that one. First, the district court ignored the framework governing emergency public health measures like GA-09. Jacobson versus Commonwealth of Massachusetts, 197, 1905. That's the case I was discussing before. Jacobson did not want to get a vaccination at the time. The Commonwealth took him to court. The federal government stepped in and said, yes, you must get a vaccination because it is a matter of public health. Under the pressure of great dangers, constitutional rights may be reasonably restricted. Well, who decides great dangers and who decides reasonable? What's reasonably restricted? I mean, we see time and time again, there's countless videos of officers being given the authority for reasonable searches, reasonable this, reasonable that, and then we come out with these videos and the officers are cleared for doing something that any reasonable human being would look at and be like, that was unreasonable. But because it's up to the officer's discretion, they can make unreasonable reasonable. It's a bit of a slippery road that we're going down here. As the safety of the general public may demand, that settled rule allows the state to restrict, for example, one's right to peaceably assemble, to publicly worship, to travel, to travel. Now that means internal borders, internal checkpoints. Don't like that idea very much. And even to leave one's home. Don't like that much either. The right to abortion is no exception. Why? Why is it no exception? I could think of a couple reasons why it would be an exception. Second, the district court's result was patently wrong. Basically, the Fifth Circuit District Court of Appeals is telling the district court that they're absolutely wrong in their decision. Instead of applying Jacobson, the court wrongly declared GA-09 an outright ban on pre-viability abortions and exempted all abortion procedures from its scope. The court also failed to apply Casey's undue burden analysis, and thus failed to balance GA09's temporary burdens on abortion against its benefits in thwarting a public health crisis. Essentially saying that the resources that are used, the masks, the gloves, the personal protective equipment, things like that, are weighed against the burden of society, against the burden of the mother, the individual that is pregnant, that is getting the abortion. The needs of society outweigh that person's rights to an abortion. Okay. Third, the district court usurped the state's authority to craft emergency health measures. Instead, the court substituted its own view of the efficacy of applying GA09 to abortion. But it is no part of the function of a court. Basically saying that the district court that put a temporary restraining order on the ban of abortions overstepped its bounds. They overstepped their authority, and they had no right to even begin to step in the state's idea of what emergency procedures should be done. But do you see how this could possibly be a slippery road? Once you have something that sets precedents like this, well, all you do is you tweak it a little bit if you're a lawyer, and you can make it set precedents for another thing. You see, I've known quite a few lawyers, and I've seen tactics like this used. So let me explain just so that you understand why this could be a very slippery road. I have seen lawyers use something like this, and then something that is totally unrelated, but you can link it because, hell, you can indict a freaking ham sandwich if you just know how to speak the words properly. And you take this and use this as precedents for something that is unrelated, but under the same purview, basically, of the law. And you get that set for precedents. Now you have two precedents, but your end-all goal is you want this law over here set into precedents. But in order to get that, you've got to get this precedence and that precedence, and then you've got to tweak it and get another law on precedence. Now you've got three laws that are set into precedents over three separate cases, and that's how laws expand like this. And that's how you get your freedoms slowly stripped away. Is it a good thing? Is it a bad thing? Well, hell, I don't know. The people evidently who are smarter than I am believe that abortions will use too many resources and that the benefit to society of banning abortions in the long run outweighs the temporary hassle of not getting an abortion now. But I know this is going to be a very contentious subject, so please comment nicely. Think about what you say before you say it. There are going to be a lot of people upset about this in both directions. I love you guys, and I'll keep you informed as best I can. You guys stay safe, and I will see you guys on the next one. But discuss this. This affects all of us more than you might think. This isn't just about abortions. This is a stepping stone. Will we stop here? I don't know. Power corrupts. Absolute power corrupts, absolutely. The more power we give those in power, the more corrupt they will be and the more power they seek. At some point, we've got to say, hey, let's put the brakes on. At some point. When do we reach that point? I don't know. Let me know. I love you guys. See you on the next one.